Good afternoon, everyone, and welcome back. And after that first panel, which has laid such stellar foundations for the ensuing discussions, by perhaps showing us the dissonances between the rights framework and realities worldwide, we will now move on to the second panel, which will be moderated by Dr. Pablo Gavira Díaz. Pablo is a project officer at the Nuremberg Academy and specialized in international criminal law and international humanitarian law. Over to you, Pablo. Thank you.
Thank you so much, Kiran. Good afternoon, ladies and gentlemen. Welcome to the second panel of this year's Nuremberg Forum. This panel focuses on the topic international crimes against children, the framework. Yesterday, we had the opportunity to learn about the instruments in force which regulate the protection of children from different perspectives under the umbrella of public international law. We heard that the Convention on the Rights of the Child, adopted by the UN General Assembly in 1989, is not only the most influential agreement in the field of the protection of children, but it is also the most ratified human rights instrument to date. This specific convention was adopted on the 20th of November, which is a very special date for international criminal lawyers. On the 20th of November 1945, the trial against the major war criminals before the International Military Tribunal began in this very same room. But one of the highlights of this historic trial took place on the day after, the 21st of November 1945, when Robert A. Jackson, Chief of Counsel for the United States, delivered his opening statement. Jackson's most known passages of his speech are found in the opening paragraph, while one of the most pertinent thoughts can be found towards the end of this statement. And I quote, "The usefulness of this effort to do justice is not to be measured by considering the law or the judgment in isolation. This trial is part of the great effort to make peace more secure. One step in this direction is the United Nations organization, which may take joint political action to prevent war if possible, and joint military action to ensure that any nation which starts a war will lose it. This charter and this trial constitute another step in the same direction and juridical action of a kind to ensure that those who start a war will pay for it personally." End of the quote. This statement, ladies and gentlemen, echoes what a few years later would be formulated as the principles of international law recognized in the Charter of the IMT, of the International Military Tribunal, and in the judgment. They are better known as the Nuremberg Principles, which give name to the institution that I have the pleasure to represent. The spirit of the Nuremberg Principles is also present in the Rome Statute of the International Criminal Court, adopted in 1998. In particular, Nuremberg Principle number 1 is enshrined in the 4th paragraph to the preamble, which affirms that the most serious crimes of concern to the international community as a whole must not go unpunished. Interestingly, the first category of persons protected by the Rome Statute is contemplated in the 2nd paragraph to the preamble. Guess which one it is? Children. The states parties to the Rome Statute are mindful that during this century, millions of children, women, and men have been victims of unimaginable atrocities that deeply shock the conscience of humanity, as it was also highlighted by Dr. Danieli yesterday. I hope, ladies and gentlemen, that these opening statements can serve as the basis for the panel discussion that I have the pleasure to moderate today. I now have the honor to introduce you to the distinguished speakers who are joining me today on this panel, starting with Professor Cécile Aptel, who is Deputy Director of the Innocenti Global Office of Research and Foresight at UNICEF. Professor Aptel, would you be so kind to give us the opening statement, please?
Thank you very much, Pablo, and thank you very much to the Academy for inviting me. Over the last few years, I spent a lot of time reading through not only the Nuremberg judgment, but also some of the transcript. I wrote a book that is called Atrocity Crimes, Children and International Criminal Courts, and it was really painful to go through these transcripts. So I had to start by really citing, not in fact from the judgment, but really from the transcript, from a statement delivered by Rudolf Höss as a witness. He had been the camp commander in Auschwitz from May 1920 to December 1943. And he provided, in this very courtroom, chilling information on the treatment of young Jewish children as they were arriving at the camp. So I want to start by reading this, as these same words were delivered here a few decades ago. He said, "We had 2 SS doctors on duty at Auschwitz to examine the incoming transports of prisoners. The prisoners would be marched past one of the doctors who would make spot decisions as they walked by. Those who were fit for work were sent into the camps. Others were sent immediately to the extermination plants. Children of tender years were invariably exterminated, since by reason of their youth, they were unable to work. Very frequently, women would hide their children under their clothes, but of course, when we found them, we would send the children in to be exterminated." These words were declared here decades ago, and of course, things have evolved for the best somehow. We certainly have an enterprise of international criminal justice that is much more solid than it used to be. One that also has been increasingly looking at having survivors come forward and tell their testimonies, which was not the case in Nuremberg. Here, during the judgment, the attention was on the crime against peace, known today as the crime of aggression, and a lot of the testimonies were about the political responsibilities rather than the stories of the survivors. Very few, in fact, survivors came forward, and none of them were children. Today, we are questioning this record, and certainly the contemporary international criminal tribunals are doing much better. That has changed, and the protection afforded to them, the reparations that can be recognized to them, have evolved. What has not changed, though, is the situation on the ground. In many different contexts today, in 2024, children are still exterminated, sometimes in a very systematic way. The striking gap that we have between a very solid and consolidated legal framework that protect children in laws and the application, the implementation on the ground, or the lack of implementation, is really striking, and I hope that that's what we can discuss. Thank you.
Thank you so much, Professor Aptel. I would like to continue with Professor Thuy Seelinger, who is a research associate professor on academic leave at the Brown School of Social Work, Washington University in St. Louis. She's also senior coordinator for gender-based crimes and crimes against children to the ICC Prosecutor, and also former special advisor on sexual violence in conflict to the ICC Prosecutor. So, Professor Seelinger, could you be so kind to provide us with the opening statement?
Thank you so much, Pablo, and welcome everyone. I'm standing in for Priya Pillai, who wasn't able to join us, so I'll do my best to fill her spot. I just added to the panel quite recently in the last 48 hours, so I'm going to just speak quite informally about some of my observations in the past working with children, although unlike most of you in this room, and certainly on this panel, I cannot claim to be a child expert all of my life. It's something that has been integral in my work as someone who focuses on gender-based crimes. But of course, I've been learning a lot while at the court on how children really warrant their own special attention under our statute and also in our practice. So I think, as the prosecutor laid out for us yesterday in his keynote remarks, the Rome Statute does, of course, anticipate the importance of children in all of our work, both in terms of our substantive crimes, but also in our procedures, the various allowances for protective measures that can be applied when children do participate in our proceedings. We have those special considerations for children explicitly mentioned in our statute. The prosecutor is urged to appoint special advisors with relevant thematic knowledge. Our judges are ideally recruited to have some legal expertise on issues including gender and violence against children. And then, of course, there are the protective measures that can take place not just in the courtroom, but throughout the investigation phase and ideally through outreach. In looking back at our work, I think the prosecutor alluded to this yesterday, we have, of course, included children in our cases, literally since our very first case, the Lubanga case. And yet there's a huge difference between looking at crimes that may, of course, involve child soldiers and truly taking a child-sensitive approach to every aspect of our work. And so this is where we currently stand at the court. How do we look beyond the context of children who participate in hostilities, for example, to how they are affected in every way for every crime under our statute? And how do we incorporate that lens and that sensitivity in every step of our work? So we are actively moving beyond that. Véronique led in our development of the children's policy that was launched in the end of 2023, and I'm in charge of implementing that policy across the office, including our gender-based crimes policy, and new policies that we're developing right now, including one focused on slavery crimes and environmental crimes. So I look forward to sharing a little bit about that work with you and how I am tasked with ensuring that both a gender lens and a child-sensitive lens is put to all of these policies, not just our children's policy. I'm hoping that in the discussion today, I'll have the opportunity to touch on a couple things. We'll see. It's a flexible panel, so I'll do my best to get to the main contributions. One is, how do we actually look at the Rome Statute in our Article 21, which really compels us to bring in the Convention on the Rights of the Child to be able to do this work fully? And how do we bring in specifically this GCRC's requirement to take a best interest approach? And so I'll talk a little bit about how we have endeavored and are planning to do that going forward. Secondly, I do want to talk a little bit about how we take a child-sensitive approach to the development and implementation of all of our policies. And then third, think with you a little bit about how we approach our substantive crimes more expansively to ensure that the way children are directly and indirectly affected by those crimes, regardless of where they fall, which article applies to them in our statute, they are taken into account. So those are the three things I'm hoping to contribute in the discussion today and also to learn from my colleagues. Thank you.
Thank you, Professor Seelinger. I would like to continue with Dr. Shelly Whitman, who is Executive Director of the Delaware Institute for Children, Peace and Security. Dr. Whitman, would you be so kind to give us the opening statement, please?
Sure, absolutely. I hope you can hear me okay, because I wasn't hearing so well, and I wasn't sure if it was my hearing is going and age is catching up with me. Thank you for the opportunity to be here, especially here in Nuremberg. Not sure if all of you are aware, but our organization was founded because of General Romeo Dallaire, who experienced the genocide in Rwanda in 1994. And his experience is what has informed the creation of our institute. I wanted to use this opportunity today to talk a bit about that connection between looking at aspects related to mass atrocities and genocide prevention and children, and thinking about the fact that we have to do a lot better in understanding how to advance human rights and peace building and reframe the way we think about children's protection, and in particular, what it means in terms of their participation in global peace and security. There's a really urgent need right now for us to deepen our understanding of these contexts that threaten children and increase their vulnerability to insecurity and extreme violence around the world, as we are witnessing on our screens on a daily basis. It also means that those contexts are diminishing the ability of children to be agents of change. And so for us to be serious about peace and security, we've really got to look at what that means in terms of how we address it. From our perspective of the Dallaire Institute, we take a unique perspective in working with security sector partners around the world, as well as with communities. And we feel it's essential that we have to look from that dual lens of, on the one hand, protecting children, but on the other hand, also understanding the realities of the security sector who are put in situations where they must interact and face children, and also have a responsibility to uphold all of these international humanitarian laws that we've been talking about, and the practicality of what it looks like in terms of implementation on the ground. So for us, I hope over this next hour or so that I can also express to you that the international frameworks that exist also have to have reality in terms of how they can be implemented effectively. And that means for us, when we looked at issues such as the Vancouver Principles that we created in 2017, which is focusing on peacekeeping and the prevention of the recruitment and use of children as soldiers, it was a way that we could complement the international framework with an ability to implement something at a national level. So I really think that, today, that if I can help to contribute to that understanding, that's my desire to be here. Thank you so much.
Thank you, Dr. Whitman. I would like then to conclude with this round of introduction with Professor Mark Drumbl, who is class of 1975 alumni, professor and director at the Transnational Law Institute in Washington and Lee University. So, Professor Drumbl, I'm looking forward to hear your opening statement.
Good morning. Thanks for the intro. Thanks for keeping it short so we can get right to the substance. It's a real joy to be here. It's not my first time in Nuremberg. I hope it won't be my last, and I'm sure it actually won't. So what do I hope that we talk about? I hope we talk about two of the human senses. I hope we talk about sight and sound. Now, what do I mean by sight? By sight, I mean, what is it that we are looking at? And by sound, I mean, who is it and how is it that we are listening to people? So what do I hope? Let's start off with sight. What are we looking at? Our gaze. I hope we can gaze beyond armed conflict, and that we can look into the realities of criminalized children, children operating in contexts of endemic criminality, gang violence, a structural apartheid, and contexts in which membership in criminal gangs, for example, can bear similar recruitment processes to membership in armed groups. What can we learn from recruitment in armed groups to recruitment into criminal gangs? There's large numbers of children worldwide who are criminalized. A second place I would like us to gaze is beyond The Hague and beyond Geneva as sites of lawmaking. There are many, many, many places and spaces in which law and practice and transitional justice is actively being made that elude at present our formal gaze. I would love us to talk about the Baraza in the Democratic Republic of the Congo, traditional forms of reintegration of violence-afflicted young people throughout the global South. I was very heartened by the ambassador's comments this morning about the work of the AU in this space. And third, with regards to sight, I think it would be great for us to look beyond extant crimes to one area that we haven't spoken about at all so far, that I think really is of huge concern to young people, and that is climate change. And how do we conceptualize climate change as intergenerational violence, and what can the law do in that particular regard? And then quickly, with regards to sound, listening. Are we really ready to really listen to what young people want? Are we really ready to really listen to their desires and experiences as they tell them to us in their own voices? Really listening means not talking over. It means not substituting their thoughts. it can mean welcoming the unexpected, and it requires dealing with the reality of juvenile agency, autonomy, and perspective. And the experiences of young people in conflict situations do not always map onto what international experts and activists necessarily want to hear. I think we need to listen. And last, I think there's another group of people that we need to listen to. And this is an uncomfortable reality, but there is another group of people which I believe we really need to listen carefully to. And those are the people who are hurt by the actions of children. And the reality is, in conflict and in criminal contexts, young people, however they got into the terrible situations of violence, do hurt others. And in my experience, the loneliest place to be is when you have been hurt and people don't properly listen to the pain that you suffered because perhaps it was inflicted by a conscripted, abused, or terrorized child. But one's ability to speak about one's pain should not depend on who inflicted that upon you. So those are the things I hope we can also talk about.
Thank you very much, Professor Drumbl. Well, to start with the topics that we are planning to address today, I would like first to speak about this sort of historical approach. When did, in this case, Professor Aptel, I would like to ask you, when did the topic of protection of children become relevant for the international community?
Thank you. It depends how far we go back in time, but we have seen a lot of progress and attention devoted to the protection of children since the UN was established, primarily, so really coinciding again with Nuremberg. UNICEF was established immediately after the Second World War, primarily to be looking after children in Europe, including German children and children of other countries, as they were also massively displaced and finding themselves in need of food, shelter, and basic assistance. And that's why it started as a fund and very much to meet the most basic needs. But in legal terms, we really, I think we need to think of a few more recent developments. Clearly, the adoption of the Convention on the Rights of the Child was a pivotal moment. And it's interesting that it entered into force in 1991, which coincided with the establishment, or just shortly before the establishment of the two UN tribunals that were established in 1993 and 1994, the one for the former Yugoslavia, the ICTY, and Rwanda in 1994. So at a time when really we saw a resurgence in international criminal justice, when there had been decades since Nuremberg and Tokyo without any international tribunals. So the Convention on the Rights of the Child, and then shortly after, in the 1990s, we see in 1996 the Grasham-Akel's report, which was referred to in the earlier panel, followed then by the appointment of the first UN Special Representative for Children in Armed Conflict. And I'm very happy to say that we have Leila Zerougi, one of the former Special Representative of the Secretary General in the room here. So we see in the 1990s a lot of preoccupation with children, and in particular, in New York, in the discussions, a lot of attention to children in armed conflict. So in the 1990s, we have a conjunction almost of children in armed conflict, and then one specific form of participation and of children in conflict, and also a specific way in which children are impacted, which is children recruited as child soldiers. And that's because Grasham-Akel very deliberately in her report put the emphasis there, because she saw that as a phenomenon that could gather attention. And in fact, it did. So much so that it gathered the attention of the UN Security Council, which then established progressively over the years first a working group of the Security Council on Children and Armed Conflict, and then that led to the progressive establishment of the Monitoring and Reporting Mechanism, the MRM, which is a mechanism in which whenever there is conflict, there are records taken place, data, evidence being gathered about initially one single violation, and again, that was the recruitment and use of children. But then progressively, the Security Council opened that up to another 5 forms of violation, hence the fact that we refer to 6 grave violations. Now, again, coming back between the protection of children and international criminal justice, I mean, we're in the Nuremberg courtroom. I think it's really important that we look at protection of children, but then also how that provided or underpinned the development of international criminal justice. I think the ICTY and ICTR paid relatively little attention to children, but they were just coming in, just after the adoption of the Convention on the Rights of the Child, when those tribunals established later in the 1990s, or like the Special Court for Sierra Leone and the International Criminal Court coming up in the early 2000s, they start to really have been more socialized into the discourse of child rights and attention to protection of children. So that's with the Special Court for Sierra Leone and then the International Criminal Court that we see the first cases concerning children. But of course, they look, as everyone was looking at the time, at child soldiers. And in doing so, they create what I actually see as a very narrow set of focus on child soldiers, which is not unproblematic because child soldiers are those that, of course, are a bit more ambiguous. They are victims of an international crime. They have been recruited and used in hostilities, but often, as was already mentioned, they also have participated in some of the atrocity crimes. And so that starts to really give a mixed image and reduces our understanding of children and armed conflict. It's only much more recently, I would say over the last 8 years or so, that we have had a lot more attention to the broader phenomenon of children in armed conflict understood as children killed, children maimed, children tortured, children detained. The actual real impact of armed conflict on children being, of course, much broader. Much broader. And it's also over the last few years that we've started to have a better approach that is an intersectional approach that looks at not just children, but at boys and girls, and the very specific forms of suffering of girls. We know that, for instance, conflict exacerbates hugely the risk for girls to be facing early marriage. And that's very interesting that this has also, therefore, underpinned the efforts, the more recent effort of the International Criminal Court in doing what I think is really a much better job at reflecting that full scope of victimization of children. But maybe just to say that it's not only been the International Criminal Court, but also the rest of the UN. I mean, Judge Navi Pillay is here, and of course, in one of the leading one of the fact-finding commission of inquiry on Gaza, and really, there's a lot of efforts that is undertaken by fact-finding mechanisms under UN auspices to now very systematically document as well the suffering of children. And I think that's something that again is very recent. It's only over the last few years that these fact-finding mechanism, commission of inquiries have had a specific explicit mandate to look at crimes against children and also have been equipped with advisors that have expertise in these areas.
Just to build on a little bit on what Cécile said, I think one of the good developments that has happened over the past 20 years is that our understanding in popular discourse on who is a child has shifted from I think what was initially a very racialized perspective of boys, mostly in Africa, very young boys, to a much more cosmopolitan understanding of children everywhere in the world that face challenges and need protection. It has shifted from boys to girls. I think there's newer work coming out now that more squarely addresses questions of gender identity also within young people. I think that's tremendously valuable. I think one of the categories that's the most difficult, however, conceptually, are teenagers, persons in the 15, 16, 17 age range. International law is incomplete in this space, as we know, and one of the themes that Pablo had actually set out for us to talk about, and if we're going to get there, is this idea of the sort of checkerboard approach of a lot of international legal instruments that set different ages in terms of protection. In some cases there's gaps, in some cases the differences are understandable, in some cases they're a bit incomprehensible. But I think what's also important in this space is not to become excessively wedded to the simplicity of chronology, to not become excessively dedicated to birthdays and years. Yes, law requires, in the instance of a certain level of clarity, to have chronology as a baseline. However, people's lives are also much more complex, and there are processes of coming of age that do have a salience that can transcend just the simplicity of a birthday. And of course, there's a risk in this kind of approach in that perhaps it may reinforce certain values that people below the 18 ought not to be fully protected. But I'm also concerned of another group that we don't talk about. Life doesn't end at 18. The world is a complicated, violent, and unstable place for a lot of 18, 19, and 20-year-olds. Neurobiological development doesn't suddenly end at the age of 18. 18 is not some nirvana where you pass from a troubled childhood into a pacific and peaceful and glorious adulthood. These same issues extend and continue. And sometimes I do worry that this excessive focus on 18 as this terminal cutoff point permits the law to come down very harshly on 18, 19, 20, and 21-year-olds. And that's also something I would just like to keep in mind. You know, life is perhaps a bit more ambiguous and fluid than always measured by a ruler.
Yeah, thank you very much. I think there's so much to explore on this issue. I think on the one hand, it's very difficult for those who are working in international legal frameworks to cope with an ambiguous age that you throw out there on the one hand. So I feel for that dynamic and for a need for some structure to exist. On the other hand, your point about brain development and the science that is far more known now than it was at the time of the UN Convention being created, right? I think we do have to explore those pieces. And there are colleagues that I have worked with in Canada too, like Christina Clark-Kazak, who speaks a lot on the chronology issue and the cultural and contextual issue of age and maturity. For sure, a child who grows up in a particular context in which they are exposed to armed violence or have had to make certain decisions earlier in life, they may have different levels or trajectories of aspects related to their future, right? At the same time, you need to then juxtapose that with the brain development issues, which show that it's much later than 18, right? And so if that's the case, then where is it that we find the common ground? So for many who are practitioners in this area, you tend to want to go with the law that exists versus trying to open up a can of worms that allows those who are perpetrators of crimes possibly to get away with further crimes by this justification. And if I can give just this one point, aspects related to wars on terrorism have only contributed to that further. I was watching a piece last night on a local news channel here about a young boy who was, I think, around 10 years old, out protesting because of the situation in the occupied Palestinian territories, and his father being a Palestinian who had come to Germany many years ago. And he was being chased down by police here for his support for that particular protest. So My challenge, of course, to all of you that I was highlighting in my initial points are that I think it speaks to some of what you were initially saying, Mark. Are we ready to listen to what some of those children are saying? And then we have to respect the fact that children have very important things to say about ending war, which don't suit some of our political and economic objectives that adults are creating in this world, right? And so a lot to unpack there, but a lot for us to think about very critically. Thanks.
Thanks. I was listening to my colleagues here, and it made me actually think about my daughter. I have an 11-year-old. She just turned 11 last week. And listening to the history that Cécile just laid out, and also Mark's comment about not being so Hague-centric, which I understand and agree with, it strikes me that maybe we are in our own adolescence about our awareness and understanding about how children should be integrated and accounted for in our international criminal justice work. I mean, it took a while, the childhood of putting the body parts together and developing the actual mechanisms. I think that's what Cécile has described for the last several decades. And now, this is, I feel like, the beginning of the social period, the socialization period in a way. So we have, at least I'll speak for the OTP's part, we're in a new period, I think, of exchange with national actors, actually. It's not just because we have a new complementarity policy, but because we've been learning so much from staff, our colleagues who have come in from national systems and worked with children in their home jurisdictions and brought those skills to our own investigations and our trials. But then also much more exchange, in this era with civil society from around the world, with national colleagues who are working in court systems in Latin America, across Africa, for example. So I think we are in this period, like my daughter actually, where she's spending so much more time outside of the house, actually, and with peers who are, different stages of development, but from whom she is learning and gathering a lot of insight and strength. And so I just think examples of what we learn from our secondees, from our staff members who come from different jurisdictions, and also colleagues, for example, in Colombia, who are now grappling with some issues that we are also facing. For example, what do you do when children within your own ranks are violated by their commander, right? So these are questions that reverberate in other jurisdictions, and we are, with technology and with this moment in time, availing ourselves of and learning from. So maybe I would add that this is part of the historical lens in the period we might be in now, Cécile. Thanks.
I think it's important that we come back to the Convention on the Rights of the Child. Yes, its Article 1 said 18, unless, by the way, the domestic jurisdictions provide otherwise, but it also has a fundamental concept that is the evolving capacity of the child. Why? Because the Convention on the Rights of the Child and its drafters, and then now the committee in its interpretation, are always trying to navigate what is necessarily a continuum from a very vulnerable child in need of protection, as an object of protection, all the way to a human being with agency. And that obviously with age, every child evolves in that continuum from in a vulnerable position in need of protection to an agent able to fully participate and make decisions for herself or himself. But then it's also a very individual journey, and it does occur in certain contexts that are cultural and, by the way, also historical. The cultures evolve in all of those places. So finding the right balance between protection and agency has to be guided by a sophisticated, nuanced understanding of the evolving capacity of the child. And that's a key concept in navigating that, again, between protection and agency. On the definition, I think it's also really important that we keep in mind that there's, in fact, I think it's not only it's not only the chronological definition is not culturally based. In fact, I think that in most cultures in the world, what makes a child is the relationship with the parents. In most language, the word child means not only being a young human being, but you're the child of someone. You're the child of your parents. And the fact that in all languages almost we find that dual meaning does speak to the relationship nature of really who is a child. And again, that's, I think, really across culture. So there are different understandings of childhood, obviously, and the chronological is not the only one, but there's also the question of the objective definition, that is, for instance, chronological, versus the subjective definition. You know, how you are defined by others and recognized as by others as being a child. And importantly, when we speak of accountability, there is the question of the self-reflective definition of a child. Because in some contexts, that you may not have a match between these. And I'll give you a very concrete example. In Liberia, a child who probably didn't know what was his age, because not in all countries do we have birth certificate. When asked, he was a child participating into one of the armed groups, and when asked, how old are you, as part of the demobilization, he said, I'm old enough to kill a man. That was his definition, his self-reflection of, his age. He was old enough to kill a man, in fact, probably had been killing people. So that's the complex relationship between protection for those under 18, and obviously that's extremely important, especially because we see so much pushback with efforts to criminalize younger children in different contexts and for different participations, including sometimes to just simply realize their civil and political rights, which they also have, even when below the age of 18, versus the self-reflection nature. And in that, I want to say that in my own experience, in different contexts, I've also seen that one of the complex issues is when you have children that becomes parents. So namely people under the age of 18 that becomes parents, and that's especially the case for young mothers who may have been, in fact, become pregnant as a result of rape. And so their children, they're protected, they were victimized as a child, but they also become mothers with all sorts of parental responsibilities and the expectations of the community that they are old enough to take care of that child. So we need to have that understanding. But again, we need to preserve that 18 as a legal, clear norm of protection, because it is questioned in many different ways and very seriously undermining the protection of children in many different contexts.
Yes, thank you, Professor Aptel. That was actually one of the topics that I wanted to cover, which is the definition of children. Yesterday, Professor Schmal was speaking about the discrepancies in the definitions, age limit. You mentioned now the age of 18, Professor Aptel. Does everyone in the panel agree with that? Professor Drumbl, for example. What do you think about this 18 age?
Well, it sort of riffs off what we've spoken about already. I think you can have clear lines, and I'm certainly in favor of clear lines, but just because you have clear lines doesn't mean that you don't have sophisticated thinking. I think one of the certain problems in reintegration of violence-afflicted children has been on the level of what kinds of programs are being designed for children. And there, I think granularity is absolutely essential. The kinds of imagery, the way one is spoken to is extremely different in terms of a 10-year-old than a 17-year-old. In particular, as Cécile correctly pointed out, it's very often the case that a lot of teenagers coming out of conflict zones really see themselves as adults, and they will see their experiences with violence in a mixed context. It may be terrible, but by the same token, it may have felt liberating, it may have been a level of independence, confidence, stuff may actually have been learned. And I think the way that a reintegration program interfaces with that is critically important, as opposed to simply talking over the young person and say, war is in all and every case is absolutely horrible, and there can be no sort of learning that occurs in those spaces. And let's be honest, peacetime can also be very difficult as well. So this idea that armed conflict is entirely determinative of the way one's life goes, that we also shouldn't put too much stock in. So one can maintain, clear categories, but they don't have to police and determine everything. And as I said before, I think it means the law comes down very heavily on persons just over the age of 18, and then sometimes too weirdly, to be honest with you, for 16 and 17-year-olds. I want to say just one quick thing, riffing off of something else that Cécile said on parents. And family. So I think this is extremely interesting. So I'm participating now in a project that looks at the role of parenting in transitional justice. And I find this fascinating as a project. Why? Because parenting and the home are riddled with all kinds of assumptions and premises of safety and security. There's a great poem called Walls by American poet Langston Hughes. And this is something that I refer to a lot in the poem. I'm paraphrasing it a bit, but it's short, so I'll get most of the words. Go sort of 4 walls that shelter from the rain can also contain so much pain and sorrow. And the reality is the family can, on the one hand, serve as some level of protection, but it can also be a really painful experience for young people. And the idea of returning back to a family, a lot of people, young people end up in militarized or criminalized situations because they want to get out of what might very well be an abusive domesticity. So I think we also need to think about this idea of parenting. And one thing, I don't know, I'm a parent too, so, you know, your kid will get older, wait till they're 17, like my older son, right? And they're completely, you know, independent or in this interstitial zone. But just to throw this out, I also can't help but wonder whether we would also do well with, in the post-conflict, not only thinking about children's rights, but also parental responsibilities, and also recognizing that the home isn't a sanctuary for everyone. It can be a tough place, even as Langston Hughes says, even if it shelters you from the wind or rain, that's not enough.
Thank you, Professor Drumbl. Sorry, which one? Yes, you would like to respond? Yes, sorry.
Sure, just quickly, I think I agree. For the law, we tend to gravitate towards and sometimes need the clear lines, otherwise we end up, everything is totally interpretive. And so I think there's a difference between our substantive provision and then how we go about the work, obviously. And I think that's where the individual assessment of the child or the young adult in front of us is critical. And so for our part, this is why we are very much in our implementation trying to build the tools that allow us to make that assessment. And we'll hear more about that later when Vero presents our children's policy more in depth. But I think for us, in order to understand, as you said, Mark, I mean, we're sitting in The Hague. We do come from many, many different places, but we do not always have a team that consists of people from the situation we're looking at. And we really acknowledge that and rely very heavily on country experts and folks who have a lot more cultural and contextual knowledge than we can about the situation we're looking at. Because the meaning of childhood differs, right? The understanding of a child's role in society, their responsibilities, their relationship with parents sometimes can be quite different and exacerbated by conflict or displacement. So I think for us, the line at 18 helps us understand the lines of criminal responsibility and what protections may or may not be invoked at what point. But we are trying very hard to have an adaptive approach based on an individual assessment of the young person in front of us. And yeah, maybe I'll just stop there. Thanks.
Thank you very much, Professor Seelinger. I would like to, we have covered already the background, we have covered the definition and the scope of children protection. I would like to speak about the framework, or to be more precise about the frameworks in plural. I would like perhaps, Dr. Whitman, can you speak a little bit about these frameworks in a broad sense? What do we mean by that?
So maybe what I wanted to pick up a little bit on is that there was a reference to a continuum of violence, right? And in the previous panel, this is why it was very important also for Dr. Mulali's work to be presented on trafficking and that connection to the children in armed conflict work is something that we need more of those exploration of those particular areas. But that continuum of violence is something where the frameworks that we currently have are being challenged. A country that the Dallaire Institute is working in right now is Colombia, as an example. And one of the things about Colombia is that it's a country that is on the agenda of the UNSRSG for children in armed conflict because it is defined as an armed conflict context, but it also has an armed violence context in the criminality. And where one ends and where one stops on these issues is very complicated in terms of how you work across these elements. But times when I've been in Colombia and I've asked the questions on trafficking of children currently there and try to bring that into the conversations on armed conflict, I generally get silence. And you don't get a lot of people who want to talk about the fact that there is an industry related to children who are being trafficked from that part of the world especially, not the only part of the world, but an important element of how that feeds into and also is tied to the profiteering from armed conflict, right? So we need to be able to break down those silos and those elements and then look at what are some new frameworks we might need to look at when it comes to how do we effectively address, how do we prosecute and punish for these issues and bring together all of these elements that exist for us to find new mechanisms. My proposition is that if we could raise out of these issues the primacy of children and the protection of children as a critical element, maybe we could start to find some common ground on how to address it instead of tackling this as an add-on or a last of issue. Thanks.
Just listening to Shelly and then going back to what we were saying earlier, here's another thing with the age of 18. To me, sometimes, whatever that age is pegged at, 18 is fine, we're going to stick with it, it makes great sense, no problem. But there's a deeper question, which is, you know, children's rights are also adults' rights, and all the things that we're talking about that need to be protected. In the case of young people, you know, all of a sudden when you're 18, as I said before, like you haven't arrived in paradise, the same problems continue to plague. So I also find what is the definition of a child's rights very, very interesting on this. So take climate change. So one of the things I found really interesting in recent years is a turn by young people, persons under the age of 18, to turn to courts, human rights commissions, including the CRC committee, to articulate claims that there are basic constitutional rights, if it's a national court, or international law rights to compel states to do something about climate change and to mitigate the effects of climate change, to take preventative measures. Lawsuit was brought in Montana, it's a state in the US, it got some juice and traction. Lawsuits we discussed earlier this morning have been brought in Germany. The CRC has had, you know, there have been child's rights and Inter-American Commission petitions brought by young people saying, listen, there's an obligation to do something about climate change. And I think the fact these are brought by children opens a door to conversations about intergenerational equity, which I think is a tremendously helpful conversations. But one thing I think that I would like us to shy away from because of excessive reliance on chronology is the reality that children's rights are everybody's rights. And yes, children may require a certain higher level of protection, and that's why there is a special human rights treaty framework for children, but let's not lose sight of that continuum, that rights continuum. So is safeguarding climate change a children's right? Yes. But as for me, I look at this as the greatest calamity the international community is facing in years ahead is security, stability, and sovereignty challenges. And I would hope that the success of young people's litigation in this isn't just consigned to the realm of a child's rights issue, but is a broad human rights issue for all of us. So I think that's also part of my, the continuum, because I don't think we're well advanced by cabining progressive development of human rights to the category of the under 18s.
I'd like to make a point that is slightly different from what has been said now by Shelly and Mark, and really come back to your question, Pablo, on the frameworks, because I do find that we sometimes use almost interchangeably children in armed conflict, child rights, international crimes committed against children, crimes affecting children. And I just want to reiterate points that are very basic, that everyone knows, but I think sometimes the obvious needs to be reasserted. The Convention on the Rights of the Child does not mean that children are not beneficiary of other human rights. They are. They're humans, and as such, they benefit from all of the other rights. The Convention on the Rights of the Child was adopted to provide additional layers of protection and the recognition of the specificities of the younger among humans. The Convention on the Rights of the Child is very unique because it is both an international human rights law treaty, but that also encapsulates elements that are taken from international humanitarian law, leading to some of the conflations, but also challenges, as was really also explained yesterday in our second keynote remark. So that's where we are in terms of the legal framework. And then there's the question of the political framework. And there's been a lot of discussions on the children in armed conflict agenda, but that's a political agenda. It's not a legal agenda. That's when and how the UN Security Council, through the monitoring and reporting mechanism, through the establishment of a special representative for children in armed conflict, that's the way it is labeled, has been looking at one specific set of children who are children living in an armed conflict, and not saying that they have different or additional rights, but just looking at them. Why? Because, as I mentioned earlier, that was a political exercise that occurred in the late 1990s and 2000, where the UN Security Council started to look at that agenda in an effort to better protect children. So when we think children in armed conflict, we're not thinking of a specific legal categories. We're thinking of a political attention to a certain phenomenon, and we should not use the terms interchangeably, especially then when we put our international criminal law hat on, because from an international criminal law viewpoint, then the question is, are children victims or participants in war crimes, crimes against humanity and genocide? And for the last two categories, crimes against humanity and genocide, that can occur and does occur outside of armed conflicts. For instance, I have in early publication really pushed for a lot more attention to be paid to the victims of sexual slavery, including early marriage, children early marriage, which I think actually qualify as a form of sexual slavery and even slavery in some context, and saying the ICC has jurisdiction if this happens in context where the ICC is seized, even outside of an armed conflict or in addition to an armed conflict. And that's when I want to come back to the continuum of violence, because we do find that for certain crimes, the continuum of violence is particularly there. And there again, I want to come back to girls, notably because today is the International Day of the Girl, so we really should all be paying particular attention today like every other day. But in so many contexts, the systematic violence against girls that takes so many different forms precedes the armed conflict and continues after there is a peace agreement. So we cannot also dissociate forms of violence, including sexual violence, that is committed during conflict from the before and after.
Add into that. I don't disagree at all with what you're saying. I agree completely. What I think is that it comes down to how you implement these things, and that's why the political agendas are important in terms of giving the space, yes, as well as the visibility to it, right? And the resources also, because one of the big problems we have is about where the money and the attention is going, and it's not going on issues related to children. And so, thinking about from that perspective, it's about how you use that to help amplify these very important points that you're raising, Cécile, that I don't think that everyone is thinking about all of the time. That was just a quick response.
Thank you very much. We're about to start with the questions from the audience, but before that, I would like to, we have spoken about the international frameworks in plural. I would like to speak about one specific framework, which is the one of the Rome Statute. Perhaps Professor Seelinger could explain to us, from the prosecution's perspective, from the OTP perspective, how was the implementation of the CRC, particularly speaking on the best interest of the office as fundamental to both substantive and procedural justice?
I have 1 minute, and so this is going to be an overview, and then hopefully in the questions we can unpack it a little further. But obviously, our Article 21 of the Rome Statute really compels us to pull from interpretive sources and really learn and borrow from instruments like the CRC, actually, and that is exactly how we have tried to center our policy and our implementation of this. And this includes how we understand a child's right to participate. Like, do we have really a child-centered approach to the way we conduct our outreach? When we plan to engage a community and develop our investigation strategy, are we including children in our audience? Do we have child-relevant information that we're disseminating? Do we have it in a child-friendly format? These are things that we're trying to be mindful of as we go forward. This is also part of the child's right to information, of course, not just about who we are and what we're intending to do, but as they engage with us, what are the implications of their engagement with us? Do they know about our decision-making vis-a-vis their participation, for example? So these are ways that we really are taking the spirit, I think, and the principles in the CRC and trying to apply it to our work. Children's right to justice, of course, means that we see them in our substantive crimes also. So whether it is a crime under Article 6 or 7 or 8, do we see how a child is relevant there in their experiences, whether or not children are a material element of that crime? Right, so if we're talking about starvation, if we're talking about deportation, as you saw in our application for warrant of arrest in the Ukraine situation, if we're talking about torture, obviously children are direct victims of torture as to their person, but we see increasingly where children are forced to witness the torture of their parents, or vice versa. Children are tortured and hurt in full view of their parents, intentionally. There are impacts that I don't have to explain to anyone in that situation. And these are things to be aware of. And we are trying very much to apply those lenses when we look at something that we seem to already know and have prosecuted for many years, torture. What is the child aspect of that crime and how it gets played out? Attacks on civilian infrastructure. We've talked a lot in the preceding sessions about attacks on schools and how that can be overlaid with some practices of abduction and recruitment of children into armed groups. So thinking a little bit more expansively there. And then the crime of persecution. We know we have a policy on gender persecution that was rolled out in 2022. Age is not specified as a ground explicitly, but there's no reason we can't consider it, and we do. It is part of the way we take an intersectional approach to the reasons of discrimination that lead to severe deprivations of fundamental human rights. And so certainly when we look at the possibility of persecution charge, we're trying to disaggregate how does ethnicity and religion and gender and age, how do all of these work together? Are we seeing that in our evidence? And if we are, then this may be part of that charge. So as you mentioned, Pablo, and I'll try to do this part quickly, even though I could speak about this for a long time, central to what we gather from the Convention on the Rights of the Child is to put the best interests of a child up front. And I think one of the challenges for us is we all know best interest as a concept, but it remains a bit of an abstraction for many people. And as I was working with our teams, I realized everyone thinks and wants to work in the best interest of the child, but we didn't yet have the tools to really concretize that. And so I go on mission with our team sometimes and I watch how they work. And we developed a tool which it's internal, so I can't actually share it fully or disseminate it, but I'll describe it to you a little bit so you get the gist of it. We take the components of what the committee has taught us about best interests, right? Not just the child's views, which are critical, but of course, the impact on family, physical safety, psychological condition and safety, any security risks even to the community. We take all of the components that we understand are critical for consideration, and we have certain questions and prompts that help us think about how we should explore that. Before mission, we have to assess as much of that as we can. There is a section on the tool that allows us to import qualitative material, whether we learn it from the child, the family, school, other sources, our psychosocial assessment that has to happen, our security assessment that has to happen. We put all of these inputs in. This is the qualitative part of the tool. And because in my other life, I'm a mixed methods researcher too, it's helpful, I realize, not to just leave it at the level of the qualitative, because then we can't act on it. It's hard to disaggregate and see what's actionable. So for each of the categories, we also have it's called a Likert scale. You've done it on the online surveys. Rank from 1 to 5, you strongly agree to strongly disagree. We've changed the scale a little bit, but it allows us to grade for each component, each aspect of the best interest assessment to see, okay, maybe it's a green light where the child's view is concerned, and maybe it's even a green light where the parent's view is concerned. Maybe there's a little bit of an amber light in terms of risk to the community. How do we understand and mitigate that? It just allows us to go through and see where is it strongly indicative of child's best interest being met, and where do we have concerns we need to be a little more careful, go back, see what's possible and what's safe. And this helps us actually think in a more structured way about the child in front of us. It requires consultation with many experts, country experts, child experts, things like that. But this allows us to be rigorous and I think safe and quite ethical in how we approach that part of the work. So I wanted to share that with you because I feel like we have worked with kids, of course, for many years, but this is, as I said, a new age where we're trying to be informed by the science that we now have and learn from emerging promising practices from national jurisdictions. And hopefully we'll find a way to share what we're doing more outwardly, because we do see this as part of an exchange with other accountability actors. So, thank you.
Thank you very much, Professor Seelinger. I would like to open now the floor to questions. Experience tells that it's more efficient if I take online questions first. So I have a couple with me. The first one is formulated by Jean-Jacques Njekida. He asks the following question. In Cameroon, several children have been killed and others displaced as part of an internal conflict. How can these children be protected internationally? Who would like to take this question? Mark? Professor Drumbl.
Well, I'm no Cameroon expert, but I think that one point that would map into that context and then also build off of Kim's points is the involvement of young people in institutions that are designed to explore their own suffering and their own reintegration and their own rehabilitation. And one of the things that at least I've noticed, and I suspect is the case in Cameroon and elsewhere, is that societies in which children have been subjected to violence, whether armed or endemically criminal, even after that armed conflict ends, gerontocracy remains, and the young people remain on the bottom of the power pyramid. So one thing that I have thought about and just want to throw out there, triggered by this particular question, relates to the involvement of young people in the institutions designed to help them. So, you know, we speak a lot about hybrid tribunals in the international penal space, the extraordinary chambers in the courts of Cambodia, special court for Sierra Leone, hybrid in terms of combining national and international jurists and participants. Well, when tribunals are called upon to assess the violence that is either inflicted against or by children, what about hybridity there? What about actually involving young people in roles that are akin to a jury, roles that are akin to being members of some kind of fact-seeking, fact-determinative process? Perhaps it's a bit easier in things like truth commissions than penal courts. But I think if we are going to take children's empowerment seriously in terms of having voice in what happens and has happened to them as a group, and if we take groups seriously, like those under the age of 18, I'd love to see more room for child agency in international criminal justice institutions.
was making sure you finished first. So at the Dallaire Institute, we've started to do work in Cameroon over the last 6 to 8 months, and the perspective that we've taken is we are working with a locally led youth organization that has been active over the last couple of years in actively working to prevent young people from joining armed groups of different variations. But when you look at the context of Cameroon, children have been denied in the Anglophone regions going to school. It's been a purposeful policy put in place, preventing them from going to school for, I think, 6 years now. And this approach by a government that has also endorsed the Safe Schools Declaration is the kind of thing that we want to also put some more political emphasis in this effort. And what a critique that I have is a point about peace agreements and peace processes as an example, is that I don't think that this kind of issue gets enough attention at the early phases and stages of those who are involved in trying to develop peace agreements and peace processes. It should have been flagged so early on, because if we do that, of course, we're going to lead to an increase of vulnerabilities of children to being exposed to armed violence, but also, like, what does it do in the long term for those young people not to be able to go to school and to have access to an education? So I just wanted to highlight that there's a really important piece here, again, on why the political agenda is so important to raise.
Thanks. But just a quick note to the colleague who posed the question. I don't know if this is an interesting option for you, but the Office of the Prosecutor, the National Criminal Court, we do have an online portal called OTP Link, and if you so desire and have information you wanted to raise for consideration, you can find OTP Link online and submit information about the situation in Cameroon. Maybe you've already done this. I'm not privy to everything that comes through, but I just wanted to make sure you were aware of that resource. And then, of course, there are regional mechanisms that might be of interest, like the ECOWAS system, and then the African Commission on Human Rights, perhaps. But thank you for raising the issue in Cameroon.
Yeah, thank you so much. We have 20 minutes left. I would like to cite one more question that we have received online before I get questions from the audience on site. So Tyne Williams asks the following question: how do legal frameworks balance protecting children's rights with accountability, particularly in local contexts where children equally bear responsibilities? Who would like to answer this question?
I'm happy to start. I'm sure that we'll have views on this as well, and others. Under the Convention on the Rights of the Child, states are encouraged, and the Committee on the Rights of the Child has called on states to establish a minimum age of criminal responsibility. And that's how it seeks to balance the protection of children with the accountability in terms of participation of children in behavior that may be deemed to be criminal. So basically what the international treaties and international law is calling on is on states to ensure that below a certain age, children's criminal responsibility cannot be engaged because children are deemed to be too young to even foment the intent, which would be necessary for criminal conduct. Above that certain age, but if it is below the age of 18, then states are supposed to establish a functioning juvenile justice systems that protect children. So where children can be ideally diversed from the criminal justice systems and have in any case also a lot of protection and prevention, which are really the key words for that justice systems. So it is seeking to protect. Now, if we look at the other side of the coin, which is when children are victims, and especially when we look into contexts where they are victims of grave international crimes, that's when we, in practice, see the balance being not in the right place, namely the fact that there is a blatant impunity gap in terms of holding those responsible for crimes committed against children, especially in contexts where they are systematically committed or when they are really grave violations. So that's an issue where we have not only an impunity gap, but really, frankly, a protection gap and a massive issues in terms of how do we move forward to better protect children in these situations.
Thank you very much. I would like to give you now the opportunity for those who are on site to ask questions to our distinguished speakers. Please, the lady, you need to approach the microphone.
Thank you very much. Is it on? Oh, it's on. It was just a quick question to ask the panelists how you engage with intersections of, say, questions of disability, race and ethnicity, how those intersect with your focus on children with disabilities in armed conflict, children of indigenous communities, Afro-Colombian children, for example, may all be affected in different ways. So just any thoughts on how to take into account those intersecting factors? Thank you.
Thanks very much. Actually, I had a note here about intersectionality on my paper that I wanted to raise, so I'm glad that you raised it. I would say that it's a very important point to think about in terms of all of the contexts in which we might work, whether it's at a country level or thinking about the gaps that exist on an international legal framework level and also at the political level. And that will vary depending on where we are and thinking about these issues. But I also think that it's something that we need to make more awareness of, that I just don't even think that it's yet enough in the political discourse of thinking about how we're framing our responses to these issues, as we have witnessed for so long in terms of post-conflict responses. But in a prevention lens, which is where I prefer us to focus, we need to think about that, most especially in terms of the vulnerability of children when there is armed violence or armed conflict that breaks out. Like, how does that make an increased vulnerability for some children because of that intersectional capacity or dynamics that we're thinking about? So I think that that's really important to raise, and then also to think about that again from the perspective of the kinds of programs we design and what that can mean in terms of young people that we are leaving out. I'll just give a quick point in terms of thinking from a gendered lens. Oftentimes we don't think enough about sexual violence against boys. And I think we really need to do more to raise that. And part of the challenge of this too comes from not only the collection of the data and the information, but it also comes from this lens that we look at it from. And in our work on thinking on aspects related to children who are recruited and used into armed violence or armed conflict, it's oftentimes an indoctrination tactic. And so we have to think about what that means in terms of ending sexual violence in the long term, because if that's your first exposure to it, and then you grow up in a system where this becomes normalized, then we have a problem in trying to prevent it in the longer term. So I think that there's a lot for us to unpack there. Thanks.
First of all, it's great that Shelly brought up the understudied aspect and I wouldn't say appreciated, but in terms of remedy, the understudied area of sexual violence against boys, to which I would also add men in conflict. On gender, one thing that I do find quite interesting, and something we haven't spoken about either here yet, and that is the recruitment of young people in professionalized, industrialized, and bureaucratized Western armies. This is another very interesting aspect, because there are quite a number of Western states that permit recruitment under the age of 18. Canada is one, the UK, the United States, there are quite a number of others. One interesting data point in the recruitment of 17-year-olds, in some cases even 16-year-olds, but 17-year-olds in Western armies, is that a very fast-growing percentage and accelerating of recruits into Western armies are 16 and 17-year-old girls, juveniles, women. Let's get so hung up on words, but folks in that age branch. And I find that very interesting on a number of levels. And certainly, it is a point not only to focus on how the needs of young people in armies in Western countries can also be properly addressed, but it's also a reinforcement point that the reality of child soldiering or militarized children is not just something that occurs in the global South. And many of the advertising and recruitment campaigns of Western armies, so to speak, really tap into young people tropes of empowerment, learning, experience, emancipation. And I also think that needs to be on the conversation level. If we're going to if we are advocating for the ubiquity of category, then the child soldier definition is much broader than armed groups in some distant other. It's very close to home.
Siobhan, I wanted to address the part of your question about intersectionality and consideration of disability, for example, and race and ethnicity. Another tool, I feel like I'm talking a lot about our tool, so forgive me. I think this is where the rubber meets the road, actually. We have, across our policies, committed to taking an intersectional approach to how we do this work, right? And so to do that, this is another concept that I think everyone agrees with and gets at one level, but then how we actually concretize it and what we do with it it's the next step. And so we do have now an intersectional vulnerabilities assessment tool, which again requires a lot of homework and pulling from different sources to understand what marginalization looks like in a community, depending on physical ability, physical health, ethnicity, just different markers of potential vulnerability and risk. And so that is something that we're asking teams to really, they're piloting this for us now. It's a newer tool. We haven't used it traditionally. But that is one thing we're doing to try to make sure we're taking into account different types of marginalization, and then also this then feeds into the individual in front of us, actually. So do they have physical needs that we need to accommodate if we are to engage them in a way that protects them and is dignified? I've been thinking about disability in a different way too, actually, and this, it's because we're thinking broadly about crimes, for example, starvation or torture. There are crimes that have been committed, but there are also the impacts of the physical, the psychosocial, and the social costs of the crimes once they are committed, and the future disability. So, for example, this is related to gender, Mark, but we've talked, I think we're not blind at this point to the fact that children do suffer from forms of sexual violence, right? This happens almost every case that we have. But what does it mean when a child, an adolescent, is raped and put at risk of a sexually transmitted infection or HIV or pregnancy? The social costs across a lifetime are different than, the still horrific experience of a 30-year-old or someone who's more established in the community. For some people, it puts their marriageability at stake, right? For some people, it affects their lifetime fertility, which may have other physical or psychosocial or social costs to them. Impacts of starvation on women who are breastfeeding and the malnutrition that might happen to children as a result. The cognitive impairments, the chronic disease that might follow because of deprivation of nutrition at a young age. So these are things where crimes can actually impact and bring about physical consequences and potential disability later that I think, we may not necessarily charge it as such, but this is part of the full story. These are part of the impacts that we should be mindful of, which may be able to surface in discussion about reparations later. So thanks for the question. And yeah, that's what we're trying. We are actually trying to be much more mindful of these issues.
Just very briefly, because the principle of non-discrimination is clearly a cornerstone, both of the Convention on the Rights of the Child and more generally in terms of all of public international law more generally, the challenge is in its implementation. And now not answering from a criminal accountability, but from a humanitarian response viewpoint, organizations, when they respond on the ground, are confronted to some extremely difficult issues that are driven, I think, primarily by diminishing resources. So if you have to respond in a context of a massive conflict, you have to respond at scale. You have to maximize and optimize the use of your money to respond at scale. And what is the risk in a context of diminishing resources is that the responding at scale means far too often not being able to then reach the most vulnerable. Because you can't respond at scale and also respond to those most vulnerable or most excluded or stigmatized if you don't have the resources for that. So that's really just to introduce one key point when really looking at protection of children in effective ways on the ground, which is that for that we need the resources to be able to do it. And maybe just to comment much more also on the basis of what Kim was saying, the question of exposure and stigmatization that we see in particular in terms of victims of sexual violence, and especially young victims of sexual violence. The challenge is that we also are operating in context where some, even that actually where some victims may even face risk of being deemed to have entered into criminal conduct. The very fact of admitting that you have been raped can actually mean that you also are the victim, in fact, of a criminal conduct in certain contexts. So as part of the pushback that we see and the criminalization that we see going on in many contexts, we see increasingly a trend of criminalizing sexual conduct for children, including when that is not something that is consented. And that creates new challenges in terms of protecting then those victims and survivors, because it's not only about not stigmatizing them, but not exposing them to further risks for them and their families as well.
Thank you very much. I see that Dr. Danieli would like to ask a question. Please switch on the microphone. No.
Do you hear me now? Okay. You're flooding me with memories. I actually chaired the working group on rules of procedures and evidence for children. And we also added the disabled and the elderly because nobody else took it on. So that was in Syracuse. Some of you remember the amazing days we had there, the very creative days we had there. And one of the memories I have, and Mark, you reminded me, was that one of the recommendations was that when the child is a witness in court, he is at an eye-to-eye parallel with the prosecutor. That is, the child is not made low or secondary. And you're raising an issue of power balance without saying it, but we paid very close attention to that. Good news I want to share is, for example, the Yazidi child I mentioned to you yesterday actually built his own NGO to help the Yazidi taken children. And he is wonderful. And Shelly, I'm sure you know Victor Ochin, who was a child soldier and is one of the greatest speakers around. And many of you know him. He's on our board, so I know him very well. So there is good news about children having their voice heard and taking their place. And let me just remind you that we just had the meetings on the rights of future generations, exactly on that, and that the Secretary General is quite committed to have children's voices fully heard. But there's one question I have, which is you mentioned you referred to parents and children as the traditional justice unit. The parents are often also traumatized. So I was thinking about teachers. They're also traumatized, but it's more efficient to train them than to train all the parents. So just I would like your comments.
quick example. That's an interesting point. I wanted to just quickly raise, there was a program we did in Sierra Leone back around 2014, 2015 timeframe, which was quite a significant period after the conflict had ended there. But one of the things that we had done is we had gone in and done research in the community where there was highest level of recruitment during the armed conflict. And we had interviewed and worked with children, teachers, parents, community workers, etc. And then we worked with another group to create some curriculum packs and things for the schools to be able to use and implement. What was so interesting about that is we went in there thinking about it from the perspective of how it would help the children with understanding prevention in the long term of violations against children. But some of the most interesting points that came back were the parents coming to us and saying, thank you for developing these materials because now it allows us to have a conversation with our children about what happened to us during the war, in which we had no ability to understand how to tell them these stories. That the children, if they relayed things, it either wasn't believed or they didn't have the proper language or context to say it in a way that they felt was child appropriate. So I think, just to say that your point is really an important one, and I think that we can achieve both aims if we think of it a bit creatively. Thanks.
Just one quick comment on the parenting. It's not only parenting in post-conflict transitional societies. I mean, children's rights is something that can happen across the board right here, right now, in the way that we raise our own families. Do we support the development of youthful autonomy, agency? How do we listen to our own children? How do we listen to other people's children here now? Conversations about lowering voting ages, having children more active in community decision-making, political decision-making. How does this interface with our new trends of hyper-parenting and snowplow parenting and helicopter parenting? How does that map on to the development of the agency of young people? I'm not entirely sure. But, this isn't only something, and I think one thing with the children's rights agenda, broadly speaking, to which we're all committed, it's not only the preserve of experts. This is something that happens every day, everywhere in the world, including here. And I wonder on the parenting front, if even parenting here and now could be more mindful, because we can talk all we want about the tragic scenarios of war-affected, war-afflicted, war-surviving children face everywhere in the world. But it's also not that easy being a young person in Germany, Canada, the United States also. There's lots of violence in lots of places, even in peacetime. There's lots of economic insecurity. There's lots of fragility. There's a real sense of powerlessness. Social media and tech, AI, we haven't spoken about this at all, I think creates a very different dimension to childhood than in prior generations. So I think there's just a huge spin-off, and with that spin-off, I'm going to shut down and we'll turn it.
I'd love it if we had more time, and I would certainly like to speak of parenting, of education as a transitional justice measures. I mean, there's a lot more to be discussed, but I'll keep just two very brief points. One on child-friendly, you mentioned rules of procedure and evidence, and in fact, it really leads us to have to at least mention child-friendly procedure. National justice systems have made huge advances in the last decades in having the criminal justice systems be that much more child-friendly through child-friendly procedures. We don't have that at the international level. The International Criminal Court has one set of procedure that applies across the board, including if you have children witnesses. That actually really showed into the first trials at the ICC, the case of Lubanga. The judges had to quickly adjourn and adjust, but what they actually took as measures was limited because, in fact, they are constrained by rules of procedure and evidence that are adult-centric. So judges can do their best, but I think we really will need at some point to question the the question of procedure and child-friendly procedure, including for international tribunals and special courts. My second and last point is really to come back to the fact that, yes, we need to listen to children, but not only because it's a nice thing to do, but because they have a right to be heard. And that's where we need to transform from having an understanding of children as victims and object of protections. They are victims. They are survivors. They are victimized in so many different ways, and that's absolutely there. But they also are agents, including the victims. They also have their voices, they have wishes, they have hopes for the future. They are trauma and they're stuck into their suffering. They are very varied like adults. And importantly, they are stakeholders in international criminal justice. They're not only beneficiary of whatever we do, they are stakeholders that have views, interests, and it's about time that we really change that and frankly, stop being adult-centric in the pursuit of justice.
Thank you very much, Professor Aptel. Unfortunately, we do not have more time for questions. I would like now to conclude, to close this panel too. I, of course, need to thank the distinguished speakers for their great substantive contribution. I learned a lot. And I also want to thank the on-site and only audience for your questions and especially for your patience. So we are going to have now 1 hour lunch break and we will come back for panel 3 moderated by my colleague, Dr. Gurian Petrosyan. Thank you very much.